Hello friends, today we'll talk about the most important article of the Constitution of India which is related to the fundamental rights, that is Article 13. In Article 13, law is defined for the purposes of the fundamental rights. It has 4 clauses and those clauses are very much important. Clause 1 and 2 talks about pre-constitutional law and post-constitutional law. That means it applies on, clause 1 applies on pre-constitutional laws, clause 2 applies on post-constitutional laws, and clause 3 says what law is, what is included within the law, within the meaning of the law for the purposes of Article 13 or for the purposes of the fundamental rights enforceability. Clause 4 is amended after the 24th Amendment of the Constitution of India to strengthen the parliamentary power of the constitutional amendment. So I'll talk clause by clause. Clause 1 says, the bare provision says, all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provision of this part, shall, to the extent of such inconsistency, be void. Shall, to the extent, the very important line is to note, shall, to the extent of such inconsistency, be void. So it is applied to the pre-constitutional laws. Pre-constitutional laws are those laws which are made before the Constitution of India came into force, before the commencement of the Constitution of India, means 26th January 1950. So those laws, the provisions of the act which are made before the commencement of Constitution of India, the provision which is contravention with the fundamental rights, which is that very provision, that not entire act but only that provision which is very contravention to the fundamental rights, that will be void. Doctrine of severability applies here. Doctrine of severability means that provision will be separated from the act which is in the contravention or which is in inconsistency with the fundamental rights. So it is very clear, the provision of that act shall, to the extent of inconsistency, be void. So it applies on pre-constitutional laws. Clause 2 says the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause, to the extent of contravention, be void. It talks about future laws, means it is giving a direction or mandate to the state by the Constitution itself, that the state will not make any law which is in contravention with the fundamental rights. Which is in contravention with the fundamental rights means that very provision of the law. Suppose the government or the state government has made any law, or central government has made any law which is in the contravention with the and not the entire law but a provision of that law which is in contravention or contrary to the fundamental rights, so that provision will be deleted or that provision will be void ab initio. So the doctrine of eclipse applies here. That means that very provision will be from the very beginning will be treated as void. So it is doctrine of eclipse applies here, and there is a case FN Balsara versus State of Bombay. In that case it was well defined, or it was made understand that what is that, to the extent of contravention. The phrase to the extent of contravention, which means to that very extent the law which is void, the law which is contrary to the fundamental rights will be void ab initio, means from the very starting, from the very beginning, as it came into force, it will be void, because fundamental right has given precedence over any other provision or any other law which is infringing fundamental right. That will not be acceptable by the Constitution of India. It is the mandatory provision by the Constitution of India, second clause of Article 13. Clause 3 of the Article 13 says, and in this article, unless the context otherwise requires, laws includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage having in force territory of India the law and force of law. That means ordinance, order, bylaw, rule, regulation, notification, custom, usage. So all these are included within the meaning of law. But it is important to know that personal law, that is Muslim law, Hindu law, Christians law, Jews law, these are not law within the meaning of Article 30. Okay, and 368 laws made under 368 are also not the law are also not the law within the meaning of Article 13. These are some exceptions which we should know. So Article 13 clause 3 second portion, that is law in force. What does it mean? Law in force includes laws passed or made by legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at or in particular areas. It's very simple. It talks about the laws in force made by the legislature in the territory of India. Legislature may be state legislature or parliament. The last and important clause, that is clause 4, nothing in this article shall apply to any amendment of this constitution made under Article 368. It is very important to note that the parliamentarians by 24th Amendment 1971 Act, they have included this fourth clause, which is important. It says that Article 368 has been given precedence over all this Article 13. That means fundamental rights can be violated, can be infringed if government if the parliament has made it, or parliament has taken the route of Article 368. So it was added, it was an effort to strengthen the power of the parliament or constituent power of the parliament. So but in Minerva Mill's case, the Article 4 was held to be void, it was against the norm of the basic structure. So in Keshwanand Bharti case, the principle of basic structure or doctrine of basic structure was invented, and after that the problem is solved, that judiciary intervenes in the name of basic structure. If any provision, even under Article 368, the law made under Article 368, if that provision violates the basic structure of the Constitution of India, that will be treated as void. The judiciary has the power to held it void. Thank you. Thanks for watching this lesson.